So good morning. Thank you for joining us for the second in the series of Brexit Brunch Week. We're Data Protection Under Brexit, hosted by Luke Dixon, Partner and Head of Data Protection for Freights. Before I hand you over, if you've got any questions for Luke, please use the Q&A function at the bottom of your screens. If you've got any technical issues throughout, please use the chat function and I can answer these. I'll hand you over to Luke. Thanks very much.
Thanks very much, Tom. Good morning, everybody. It's a nice sunny morning in southeast London, where I'm talking from. So spring has sprung, and we've got our roadmap to freedom. It was published yesterday. So what better way to celebrate than talking about a conflagration of everybody's second and third favourite topics after COVID, namely Brexit and GDPR. I'm told that this is actually the best subscribed of the Brexit Brunch webinars that we're providing to people over the next week or so. So thank you very much indeed in advance for your interest in this topic, and I hope it's an interesting and productive time that we spend together this morning. So as Tom said, I'm a data protection specialist working nominally out of the London office at Freights, and I head the Freights data protection team. So I deal with all matters GDPR and other forms of information law as well. So moving on, I'm going to ask Tom in true Chris Whitty style to move next slide, please. Let's take a look at the agenda for what we'll be talking about today in relation to where we are with data protection and Brexit. So the first thing I think appropriately we'll be discussing is the background, the sort of the fallout post-Brexit transition period and where we stand just in terms of general principles under the Trade and Cooperation Agreements, or the TCA as I will call it for short here. Then what we'll do is drill down a little bit more into some of the key issues and areas that UK businesses will be facing post-Brexit. And I think probably the main one that's been exercising people, certainly I know that I've had a lot of queries from clients in particular in this area, is how to handle data transfers to and from the EEA, and where we actually are in relation to that, because you might have seen there's actually some big news and developments in this area coming out of the European Union last Friday. The next point is particularly of interest for those businesses which process data cross-border between the UK in the EU, but who aren't established in the EU, and that is appointments of EU representatives. So we'll be looking at what an EU representative is, when you need to appoint one, and how, importantly, you should appoint one or go about appointing one, because that's a new issue that businesses have been starting to grapple with. We'll also be looking at the issue of EU Lead Supervisory Authorities, particularly now that the UK Information Commissioner's Office is no longer capable of being a lead supervisory authority for the EU post-Brexit. So again, we'll be seeing what this matter actually relates to, and how you should go about it if choosing a supervisory authority, if you can, or if you're affected by the post-Brexit changes. And then at the end, we'll be talking about, I suppose, the more housekeeping points. So what I've called the "and not forgetting" slide, which really revolves around things like amendments to policies, records of processing, and other things that you might otherwise overlook in dealing with the really hot topic issues which I've just mentioned, but still need and deserve a bit of attention as well in terms of tidying up now we're out of the transition period. So let's move on to the next slide. Where are we now? Where are we left after the end of the transition period? So as we all know, the Brexit transition period ended on the 31st of December 2020, and under that transitional period we were still basically working under GDPR, and it was kind of business as usual in essence, in relation to our data protection relationship with the EU. But that's changed now. We are now a third country and therefore we no longer have to operate under EU rules in terms of data protection. That said, there's a sort of a tension here, because on the one hand, we're a third country, and that entails certain things and has certain consequences, as we'll see. But on the other hand, we've chosen very consciously and deliberately to remain quite closely aligned to European data protection law and therefore the GDPR. So as part of this, we've implemented the GDPR, or what is now we would now call the EU GDPR, into our national legislation as the very imaginatively titled UK GDPR. But, you know, whilst it's not in a very imaginative title, at least it does what it says on the tin. It implements GDPR and therefore 90% plus the same laws and standards. And that UK GDPR sits alongside the UK Data Protection Act 2018, which has been in place since GDPR was originally introduced into the UK law about 3 years ago. So yeah, effectively, GDPR rules and standards continue to apply to UK and indeed to EU cross-border processing. So you will find yourself, if you do process data cross-border between the UK and the EU, working under both UK GDPR and EU GDPR, but mercifully and for the foreseeable future, there'll be, as I say, 90% plus the same thing. So we then had of course, the Christmas Eve arrangement that the UK and the EU entered into, and that was recorded in the TCA. So what does the TCA say? Because that sort of sets, if you like, the picture for the UK's data protection relationship with the EU going forward. Well, to be honest with you, it doesn't say an awful lot about data protection, but it does set out a couple of broad general principles. The first is that the parties agreed to maintain a mutual commitment to high data protection standards. And I think we can see that reflected in the fact that the UK has incorporated GDPR into its national legislation. The next thing that it set out as a general principle is that the parties agreed to continue protection for individuals from unsolicited marketing. So we've been working under our national legislation derived from the EU Privacy Directive for a number of years in the UK. And that was a piece of European legislation which restricted the way, amongst other things, marketers could send direct unsolicited electronic marketing to individuals and recipients. So we'll continue to operate under that legislation, but it also might mean that we align ourselves with any future successor legislation to that as well. So I think that's something else that we can expect to see, is a continued alignment of high standards in terms of protecting individuals from unsolicited direct electronic marketing. Also, and very importantly, it threw in a 4 to 6 month grace period commencing on the 1st January 2021 in respect of EEA to UK data transfers. We'll talk about this in a bit more detail just in a moment, because this is probably the hottest top GDPR Brexit topic for data protection of them all. But the purpose of this basically was to allow the continued free flow of personal data from the EU to the UK without any additional requirements of safeguards or mechanisms or legitimizing methods, and basically to maintain the status quo for a further 4 to 6 months. That status quo had existed during the transitional period and indeed when we were an EU member state. And the purpose of this grace period is to permit the EU time to decide whether the UK is an adequate country, and therefore, in other words, has adequately protected laws to continue to receive the free flow of personal data from the EU. So that's sort of setting out the background and the general principles of where we are. Let's drill down into a bit more detail into the main areas and the main topics in, as I say, a bit more detail. So we're getting asked a lot of questions now, very understandably, about where we are with EU to UK data transfers and how they should be handled. So but we'll talk about that, and we'll see where we stand and how businesses might approach things from this point. But I think it's probably useful, particularly for those who aren't so familiar with this area, but are having now to grapple with it, to just take a step back. And in that respect, it's important to understand that the GDPR has always restricted the transfer of personal data from the EEA to most non-EEA countries. And the only non-EEA countries to which you could freely transfer personal data are ones which the EU has deemed to be adequate. And as I said, when we talk about adequacy, what the EU means is that the laws in those data importing third countries are sufficiently protective of the EU personal data that the standards of protection are similar to those in the European Union. Prior to Brexit, the end of the Brexit transitional period, obviously, firstly, the UK was an EU member state, so we benefited from the free flow of personal data within the EU. And during the transitional period, that was maintained for 12 months, ending on the 31st of December. However, that ended on the 31st of December of last year. And then, as we said, the EU introduced a grace period, which potentially was for 4 to 6 months, but potentially ends in June of this year. And as I mentioned before, the purpose of this 4 to 6 month period is for the EU to determine whether the UK does actually have sufficiently adequately protective laws for the status quo to continue. And we said that the UK rather has aligned itself closely with EU law by incorporating the GDPR, by saying under the TCA that it wants to continue to maintain high standards. And I think this is all very much part of the UK seeking to secure adequate status. So if we move on to the next slide. Before we talking about the more, I suppose, complicated, slightly more vexed issue of transfers of data from the EEA to the UK, important to note that the UK government, pretty much within 2 weeks of the Brexit referendum vote, said that flows of data from the UK to the EEA will remain free flows without the need for any further legitimizing measures. So in terms of your flows into the EEA, you don't need to worry so much about those. They will continue to flow freely. The great news is, or at least the very encouraging news is, in terms of the adequacy decision, is that last Friday, the EU issued a draft decision on adequacy, which recommended that the UK would actually be granted adequacy status. So it looks like we can be confident that we will secure adequacy status by June 2021, and accordingly we will continue to be able to receive free flows of personal data from the EEA for 4 years thereafter. And every 4 years, assuming we are granted that status, the arrangement gets reviewed to ensure that we're still maintaining sufficiently high standards. But anyway, that is still, would give us businesses a good deal of comfort for the medium to longer term. So whilst, however, it's very encouraging that the draft decision has been issued in our favour, it's not guaranteed that we will still be given adequacy status, because the draft decision still has to go through an approval process. So I think prior to Friday's announcement, I was saying to clients that I was quietly confident that the UK would be deemed adequate from June 2021. I'm now full-blown confident, but I can't give people guarantees, as 100% guarantees, that it will still be the case. So still a little bit of scope for being tentative about this. So it's also therefore a question of what do we do next? And I think it's a good place to start is, what is the ICO as a regulator saying? And whilst the ICO issued a blog announcement saying it very much welcomed this milestone being achieved and thought it was a good step forward, as far as its advice remains for the time being, although it's worth monitoring this, that it recommends organisations still think about putting measures in place just in case ultimately we don't get an adequacy decision. And that would involve a number of steps. So if you are receiving, you know that you're receiving personal data flows from parties in the EEA, the first thing you should do is to review and map those data flows to be able to identify them. The next thing is, particularly if you're trying to make, I think, a risk-based analysis about how much time and resource you want to put into dealing with these transfers, particularly in view of the draft adequacy decision, is then to prioritize the key transfers that you receive. So the ones maybe where the transfers are the highest volume of data or are the most have the most sensitive data in them. Once you've identified those flows and you prioritize your key transfers, then it's a question of considering alternative measures to legitimize a transfer in case we don't get adequacy. And one of those key areas is or mechanisms that people have been using or thinking about using is what we call the standard contractual clauses, or SCCs. And these are basically a set of non-negotiable terms which impose roughly GDPR standard obligations and protections for data upon the party which exports the data and that which imports it. So this is a very common fallback for businesses who've been trying to work out how to legitimize their EEA to UK transfers. And once you've decided on which alternative you want to use to legitimize your transfer, then it's just a matter of implementing it. And that will be a case probably of sending out contractual variations saying, hey, we've identified a flow from you to us in the UK. We need to incorporate these SCCs probably into our agreements to make sure that the flow continues to be legitimized. But as I said on this slide, the question is, do you need to devote time and resources? And I know that clients have been receiving pushback on it. I think that the matter is also slightly complicated by the fact that the current SCCs that one would use are potentially due to be replaced quite soon. So the EU has issued new draft proposed SCCs to replace the current ones. We are expecting those to be approved by the end of this quarter, so probably by the end of March. And once that's done, there will be a 12-month grace period for businesses to implement them. So I think if you're a UK business or in the compliance or legal department, you're thinking, okay, I've got time and resource I've got to potentially devote to this. We've got the SCCs coming up, and then we've got a draft adequacy decision, which is telling me that more likely than not, things will be okay. What should I do? I think it's very much a case of taking a risk-based approach to this. I can fully understand why people wouldn't want to spend lots of time and money on legitimizing these flows only in June for us to not require that extra legitimization. So I think some businesses who've already gone a long way down this route when they were planning for the potential no-deal Brexit, I know that some of those are actually just deciding to finish off the project if they're pretty much done and saying, well, at least it gives us, we can be very risk averse, and it gives us some, more security just in case the worst happens and for some reason we don't get an adequacy decision. Those who aren't very far down the track or haven't done it might well take a different view. And they might say, actually, I'm going to wait out the adequacy decision, only spend the time and money if I absolutely have to, or wait till closer to the time. Or you might take a middle ground. And as I said, once you've identified the flows, prioritize the key ones and say, we're not going to sweat the smaller stuff in view of the reduced risk now, but we will at least make sure that we're in a good shape, potentially, if the worst happens, in relation to our top 5 flows or our what we know are our most important flows. So that's basically, I think, where we are in terms of data transfers, and that's hopefully a bit of insight into how the market and the various industries are approaching things. as things continue to change, news continues to come out and developments continue to occur. So I'd always say, do keep an eye out for regulatory developments and other news, because the picture is changing all the time. If we move on to the next slide, please, Tom. The next question issue is appointment of EU representatives. So the EU representative is a person or an organisation. The need to, or otherwise to appoint one, derives from Article 27 of the GDPR, and that has been known or referred to by some people as the forgotten article. And actually, it was one that UK businesses didn't have to worry about until very recently, because we were part of the EU. Basically, as we now know, as we've seen, post-Brexit, UK organisations who process cross-border between the UK and the EU now have to comply with two regimes, albeit those regimes are very similar: UK GDPR and EU GDPR. We are also, of course, outside the EU and its structures, and we're a third country. So basically, the position is that GDPR has always required organisations to appoint what is called an EU representative, where they offer goods and services into the EU and or monitor persons in the EU, but they are not established in the EU. So in the old pre-Brexit days, this, from my experience, has tended to be the kind of, this provision captured lots of international businesses who perhaps had websites and they were selling into the UK and the EU, but they weren't established there. So for instance, an American business with no establishment in Europe at all, but did have a website that was pointed, if you like, at European customers. But of course, now we're actually, UK businesses may well be in that US company's position if they don't already have an EU establishment. So what is an EU representative? It's basically, can be a person or more likely an organisation, which is a contact point for data subjects and data regulators in the European Union in relation to GDPR matters. So in other words, really it's saying, because you're no longer in the EU, we need to have somebody or something in the EU, which could be, if you like, without minimizing role, a glorified postbox or a point person for any issues that arise in relation to your data processing activities in the EU. So you'll probably think at this point, okay, right, I might need to appoint one. Do I need to really? I think the first filter is, do you have an establishment in the EU? If you do, then you don't need to worry about it. An establishment is actually quite broadly drawn under European law. It can be, for instance, a branch office. So it doesn't actually have to be a very high level of operation. There are also limited exceptions from the requirement to appoint an EU representative, even if you do have an establishment. So public authorities don't have to appoint one. And also you don't have to appoint one if your monitoring or processing of the EU data is only occasional. So if you move on to the next slide, we've spoken about what an EU representative is, whether you, in theory, might need to appoint one or what the exemptions are. What's the timing for appointing an EU representative? Well, now really, if you're in a position where you have to appoint one, the clock is ticking, because actually you had to appoint one, you have one in place really from the 1st of January of this year. However, so I really think that the point is to say that if you need to appoint one, you should start looking for one to engage now. Otherwise, you need to get one in place before you offer goods or services into the EU or monitor their behaviour, and you're not otherwise exempt. So how do you go about appointing one? And this is another question that's cropped up a number of times in recent months, and certainly in the build-up to the end of last year with the threat of the no-deal Brexit looming. We got a number of questions from clients around this. The market for EU representatives is actually still quite a nascent and immature one. So picking one can be quite tricky, and it's difficult actually to pinpoint and to recommend EU representatives who you know are well versed in performing the role, because it is a new market, certainly for representing UK businesses. But I think it always pays therefore to go out and do a general search. For instance, the International Association of Privacy Professionals has an approved list of vendors who might be able to assist and has details about that. We at Freeds, if you would like to approach us, can also provide you with recommendations, including identifying from that list. But also, even a general Google search will help you, I suppose, get a universe, if you like, of potential vendors. But after that, it's a question of doing some level of diligence to understand how they might be able to support you as an EU representative. Firstly, they need to be able to represent your organisation regarding its obligations under EU GDPR. So, having some confidence that they could do that and they could be a capable and resourceful point person is important. You also need to put in place a written agreement or a written arrangement, at least, with the EU representative, which sets out the terms of your relationship with them. So what is most likely is, if you're approaching or looking to engage a reputable one, is that that they would say, here's our services agreement. And then it's really a question, I think, of reviewing the service agreement to make sure there aren't any red flags there which cause concern were you to engage them as a service provider. So as we said, it's a developing market for service providers. Difficult at this stage to say who the best players in the market are. So I think important to do solid due diligence. I think, look at what's offered on the website. Is the website professional? What does a service agreement look like as well? And then you can proceed with a bit more, a measure of confidence in relation to using them. Don't forget to also, where you do appoint an EU representative, to update your privacy notice to reflect the appointment. And remember that where you do appoint an EU representative, you remain liable for GDPR breaches. You can't pass on basically that responsibility to the EU representative. It did look like, actually, a few years ago, that the EU representative was going to have to take on a certain degree of liability itself. But the EU Data Protection Board, which is, if you like, a think tank in the EU in relation to data protection and offers guidance in this area, actually did a volte-face at 180 and said, actually, liability for EU representatives will be actually pretty low, or low responsibility under GDPR. So that's EU representatives, and whether you need one, when you need to appoint one, how you should go about it. There's a next topic that you might need to consider, relates to EU Supervisory Authority, so EU data regulators, and when you might need to appoint a lead supervisory authority. So again, as we've seen, UK now a third country outside of the EU infrastructure, including the data protection infrastructure. We can no longer take advantage of something that was called the one-stop shop, the data protection regulatory one-stop shop, which the EU runs. Basically, the one-stop shop in certain situations allows a business to appoint a single data regulator in the EU to be the main coordinating data regulator that it deals with in the event of investigations or reporting data breaches, enforcement actions and things like that. So in other words, it was a really good way of streamlining regulatory processes if you had an issue with your data processing activities in the EU. Now we're outside of the EU. The UK ICO, the UK data regulator, is no longer part of One Stop Shop. So you're now in a situation where if you conduct cross-border data processing between the UK and the EU, and your current lead supervisory authority, well, your lead supervisory authority had been the UK ICO, you might now need to appoint a lead supervisory authority for the EU as well. So you're dealing with the UK ICO and an EU supervisory authority, or indeed authorities, if you can't appoint a lead one, going forward. So that's why it's good to understand whether you need to appoint one and how you should go about it. I'll give an example, particularly, say it's a personal data breach. You've got a cross UK EU personal data breach. It'd be great to be in a position to be able to say, we don't have to necessarily report all our breaches, the breaches to a whole bunch of EU regulators. We can just streamline it through one. Might not always be available as an option to you, but that's why this is a useful and important topic to understand. So how do you go about determining what you do in this scenario and how you might go about choosing one if you can? There are several different scenarios that play out here. It's a bit complicated, but I will do my best to simplify the situation. So if you're a business that processes data in the UK and in an EU country, what will your supervisory authority be? Well, certainly for the UK, it'll be the ICO. And if it's in that one other EU country, it's pretty clear that you will be dealing with the supervisory authority in that EU country. So if you're only processing in the UK and France, it'll be the UK ICO and the French CNIL. What happens if you then process data in the UK and 2+ EU countries? Well, again, it'll be the UK ICO for the UK, and then you be in a position to determine the lead supervisory authority you should pick in relation to one of those other 2+ EU countries. And if you only process personal data in the UK and you're not established in the EU, but your processing significantly affects the EU, you're in a more difficult position, because you may well not be in a position, therefore, to appoint an EU lead supervisory authority. You will be subject to the UK ICO for the UK processing, and basically the EU authorities where your processing affects people. So unfortunately, there might be multiple authorities. You might not be in a position, therefore, to pick a lead supervisory authority and to streamline. So if you are in a position to determine a lead supervisory authority, how do you go about that? If we go to the next slide. So there is a European Data Protection Board guidance in relation to this, and again, that is quite wordy and quite complicated, so I'm very much boiling it down here a lot and speaking from a high level. But if you've got just one establishment in the EU, and it's pretty clear, most likely, that your lead supervisory authority will be where you're established in the EU. But if you've got multiple ones, the issue gets a bit more complicated. The first consideration you would have is where is your place of central administration in the EU? So if you've got multiple establishments, it's really the place where the main decisions of the overall decision making is made in relation to EU data processing. That is most likely to be your best pick for the country where you should have your EU lead supervisory authority. Again, as you've seen, if it's a single establishment you've got in the EU, pretty clear what you need to do there. Again, alternatively, if the central administration approach doesn't work for whatever reason, and again, as I said, the guidance on this is pretty complicated, then you might also look to which establishment, multiple establishments in the EU, has overall control of the group. So in other words, where is your HQ? That might also be the place where you seek to have or choose to have your lead supervisory authority. So just taking a step back, as we've seen in this section, one of the consequences of Brexit is that whilst we're still closely aligned in terms of our legislation with the EU, we are a third country. This has a knock-on effect for those businesses that process data cross-border between the UK and the EU. This may well affect, or this will affect, the regulatory framework that a business has to operate within, and when it deals with that cross-border processing, if there's an issue in relation to, say, personal data breaches, enforcements, investigations, etc. And therefore that sort of necessitates the importance of determining whether you need to appoint a lead supervisory authority and how you go about doing it to at least take advantage of the EU one-stop shop mechanism, which would help make things more streamlined for you in responding to investigations, etc. Might also just mention at this point as well that because you've got separate UK ICO and EU data regulator framework now, it raises the spectrum, the possibility that in relation to the same breach, you might be facing regulatory sanction from both the UK and the UK regulator or regulators. So it remains to be seen how that plays out. There's no express obligation on the UK regulator to cooperate with the EU ones. But again, that's one of these situations that we monitor with interest, because that could be, as you see, quite burdensome or increasingly burdensome on UK businesses from a sanctions perspective. So moving on to, I think, the last point, just these really more the housekeeping issues, but ones which are sort of still worth remembering. What else do you need to keep an eye on post-Brexit in relation to data protection? The first is you need to review your privacy notices and policies, and that's doing things like ensuring that there are issues relating to or references to third countries are amended. Also amending any references to EU law and to GDPR to take account of the fact that we're under UK GDPR, EU GDPR, etc. If you've got an EU a data protection officer already appointed, you might also need to consider or want to consider whether that DPO is responsible for UK and EU data processing, or whether you want one for the UK, one for the EU. And I don't think there's anything particularly stopping you actually from having a DPO that straddles both the UK and the EU, incidentally. But again, still worth thinking about. Records of processing. So a lot of businesses will have had to have introduced Article 30 records of data processing, which sets out how they process data and why, and what the data is and who the data subjects are, etc. These have had to include details of data transfers to internationally to not adequate third countries. You now should take a look at, revisit those in case you need to take account of the fact that the data transfers from the EU to the UK may fall under that rubric, and therefore put in details about those and how they would be legitimised. So hopefully it would be an adequacy decision in our favour, but we shall see. And lastly, we've got binding corporate rules. Not many businesses have binding corporate rules, but binding corporate rules are another mechanism by which you can legitimize your data transfers. To the extent you have BCRs in place, you need to submit BCRs that have been approved by the UK ICO in the past to a new EU BCR authority to get those sort of refreshed, if you like. And also you might need to remove references to the EU in BCRs that you have which cover the UK. So now we've got the point of any questions. Tom, can I just ask how many minutes we've got left for questions, please? Want to see if we can get
15 minutes left for questions, Luke.
15 minutes left. Right, thanks very much. So we'll get through as many of these as we can. I see we've had a few. So the first question I've got in here is one of which we touched upon earlier in the talk. When entering into contracts which involve transfer of personal data in both directions over the next 4 months, do you recommend ensuring the company has SCCs in place just in case the UK is not given an adequacy decision? This is the route I'm taking, but I'm getting pushbacks. Well, as I said earlier in the talk, I can certainly sympathise with your position. I understand that compliance persons are getting pushbacks in that area. As I said, I think it's a question of taking a risk-based approach now, understanding that we can have a decent level of confidence we will get adequacy. So I don't think you need to overcommit yourself, particularly if you haven't started the legitimization process yet. So I think it's really a question maybe of focusing on key transfers, maybe not spending small stuff on the less significant transfers at the moment, and also monitoring the situation to see whether we get an adequacy decision in advance of June. Okay, the next question I've seen is, has the GDPR been replaced by a new Data Protection Act? Do we need to amend references to the GDPR to the new act and our policies and notices? So the GDPR has not been replaced as such. It's just been, as I said, it's sort of implemented or incorporated into our legislation as UK GDPR. The UK Data Protection Act 2018 continues to sit alongside that. And as I mentioned just now, you should take a look at your privacy notices to ensure that there are appropriate references to UK GDPR or EU GDPR accordingly. Next question again sort of relates to transfers, and it's asking what is the impact if you use pre or post EU or UK model clauses. So the model clauses are the SCCs, the standard contractual clauses. There isn't actually a distinction between EU model clauses and UK model clauses. We would continue to use the EU approved model clauses. I think really the difference here might be, if you have to use them, is whether the model clauses or the SCCs will be the ones which derived under the old directive and which we've been using up until very recently and still use, or the new ones which are currently in draft form and will be hopefully approved by the end of March. So I think the impact there basically is, again, depending on where you sit with your data flows, this actually might in the end be more relevant to your data flows from the UK to non-EEA third countries. Keep an eye on the situation with the SCCs, and then consider about how, if you might need to apply them to your non-EEA international transfers. Work out how you might approach that over the 12-month grace period which will ensue potentially from the end of March. But really how you go about that is a whole different ball game. And I rather suspect and hope that it will be more impactful on those businesses who are thinking about their UK to non-EEA transfers, rather than, I suppose, if you like, their Brexit transfers from the EEA to the UK. A further question I've got is just to confirm, if you have an establishment or entity in the location, you not have to establish the LSA in the Lead Supervisory Authority in each location. So situation here is, I think if you've got one establishment in the EU, then yes, it's most likely is that your Lead Supervisory Authority will be in that one place where you've established. It just gets a bit more complicated if you've got multiple establishments. Then you're going to sort of need to take a step back and sort of consider the European Data Protection Board guidance, which one of those countries in which you have an establishment in the EU is the one where you pick your Lead Supervisory Authority. And as I said, more often than not, it's going to be the establishment where you have central administration in the EU. So the place where the decisions really are made in relation to data processing. So got lots of other questions. This is great engagement. Thank you so much as well for your time on all these questions. It's always really interesting to answer them. So I'm looking down, I'm trying to get through as many of the ranges these as possible. Firstly, I've got a question about where we clarify where Turkey stands in the EEA. I transfer a lot of data to our HQ in Istanbul. Well, Turkey's not as yet part of a member of the EU, or indeed the EEA. I think the other EEA, the EEA comprises the European Union plus, I think it's countries like Iceland, Liechtenstein, places like that, but not as yet the Turkey. So Turkey would be a third country internationally for transfers from the EEA to Turkey. So without getting too sidetracked, I suppose, in it, you'd be faced with similar issues, I suppose, around legitimizing transfers from the EEA to Turkey, or indeed the UK to Turkey, because at the moment, Turkey is not deemed to be an adequate country. So I suspect that if you're looking about how you need to deal with those transfers, be it from whether it's from the UK or the EEA to Turkey, you're probably starting to look at things like SCCs to cover that. But again, that's really, I think it's another consideration. Can you share a copy of this presentation? I understand that this presentation is being recorded. Again, I'm just going to ask Tom here, are we sharing a copy of this presentation?
Yep, I'll share the slides and the recording later today or tomorrow.
Then we've got establishment in the EU, just a group company count or subsidiary company. Yes, that could potentially count as an establishment in the EU. As I said, actually, the threshold for being established in the EU is pretty low. So, I mean, I'd always recommend looking into this question, because it can be a relatively complicated one, in more detail in the guidance. But I mean, that sounds like that's certainly an option, an argument you can make. If the UK gets an adequacy decision, do you still need an EU representative? The answer is yes, you do, because adequacy covers data transfers. It is relevant to data transfers, but it doesn't really cover other issues. So it doesn't get us out of having to appoint an EU representative, because it goes back to what I was saying at the top of the talk about this sort of tension between us, on the one hand, being closely aligned to EU law going forward, which helps us get an adequacy decision, which helps us get transferred data. But on the other hand, we're still outside the EU, and we're a third country, and we're outside their infrastructure. So that's why you still need potentially an EU representative if you're not established in the EU. See if we can get through any more of these. I think we've got 2 minutes left. So I see we've had a further question about on the same topic. So we've also got, let's see, what is the reach of the UK GDPR? Does it apply to data imported from third countries and processed into the UK? So yes, so the UK GDPR will clearly apply to processing which occurs within the UK, and the GDPR upon which it's based has extraterritorial reach in some respects, and the GDPR always has been quite an extraterritorial piece of legislation. So if you are offering goods and services into the UK from outside the UK, you will need to comply with the UK GDPR, and indeed the UK Data Protection Act. As to imports of data from third countries and processed in the UK, I assume that question sort of revolves around transfers. What do you do about transfers? And I mean, that again is a whole other issue, really. I mean, I think to answer that question, you'd have to do a survey of all the other countries internationally which import data into the UK to determine whether those transfers need some kind of coverage. But I think really the bottom line is the UK, the GDPR has always been a lot more restrictive about transfers out of it to third countries internationally than third country international laws have been about their transfers into the EU and into the UK. So I think probably, there might always be countries out there which have some kind of restrictions on their laws, but by and large, not actually the issue with importing into the UK. I think going forward, it'll be more an issue legitimizing transfers from the UK outwards. So I think that's our time up. Thank you so much for your time and your attention and interest in this topic. It's been an absolute pleasure talking to you and presenting you today. Thank you for all your questions as well. A real bumper crop of questions, and sorry I can get through all of them, but we'll be looking to follow up in due course to those we couldn't answer on the day. So all remains to be said is thank you very much again. I hope you found that insightful and practical and useful, and enjoy the rest of your day, and also the rest of Freeth's Brexit Brunch Week if you're attending any of the other equally interesting and insightful talks that we will be presenting on Brexit law issues. Thank you very much.